Hi, I'm Richard Kemp, and in this vlog we're taking a quick look at the issue of data retention in law firms. It's not so long ago that firms held onto documents and timesheets as long as their systems storage would allow. With the introduction of GDPR, attitudes have changed, but many storage habits haven't. And from the legal standpoint, there are four key aspects of data retention: who owns the file, firms' regulatory duties around client information, GDPR, and firms' contractual engagement terms. The general law makes a distinction between documents prepared where the firm is acting as the client's agent, which the client owns, and where the firm is acting as professional advisor, which the firm owns. Documents that the client owns typically include communications as agent to and from third parties, original documents, and final versions of documents like agreements and submissions. Documents that the firm owns include copies of letters and emails, meeting notes, drafts of agreements, and time and accounting information. The firm and its individual solicitors are also subject to the SRA codes of conduct. Here there can be tension between the SRA rules and how assertive the firm wants to be around data ownership, disclosure, and retention. Will it want to lien over documents for unpaid fees? How will it handle disclosure requests in the context of a potential client claim, for example? It's really the GDPR that has put data retention under the spotlight, and key GDPR points are around subject access requests, SARs, and duration. Generally, SARs give an access right only to the personal data of the individual making the request and apply only to that specific personal data and not to documents. The storage limitation principle in GDPR is that personal data should be kept for no longer than is necessary for the purposes for which the personal data are processed. This is what in practice has exercised law firms and caused them to develop more elaborate data retention policies over the last few years. All these points, file ownership, regulatory duties, GDPR duties, come together in the firm's engagement terms and privacy policies. Engagement terms can contractually override the who owns what general principles, and firms increasingly set out in their privacy policies legitimate interests as the basis of lawful processing for personal data they retain. Most firms don't currently state in their privacy policy what the data retention periods are. Where a period is stated, it's typically 7 years after the final bill. Law firms have traditionally been magpie-minded about information. These developing rules are increasingly deterring firms from retaining anything that glitters and are encouraging a more disciplined and structured approach. If you'd like to find out more, please check out our website at kempitlaw.com.